We are very interested tonight in having you watch us because we have a great topic. We're going to be talking about elder law. Doesn't necessarily mean you have to be elderly to pay attention to our show tonight. And I think most of you, if you watch Life Ahead regularly, will be familiar with our guest this evening. That's Bryan Nugen. Bryan, thank you for coming again.
Thank you, Sandy.
He's just always wonderful. He always gets a lot of phone calls, so I will tell you right now, you want to get a phone call in early, you'll see the number here on the bottom of the screen, and 969-2720. Call with your questions. We have a phone operator in the control room that will take your questions, and we would love it when you talk to us on the air. That way, if Bryan has a question back to you, you're right there on the phone. But if you're not comfortable with that, that's okay. The phone operator will take your question, and then they type it up and send it out here to the studio so I can read it to Bryan on the teleprompter. So we'll look forward to hearing from you. Bryan, I know we're going to talk about elder law,
right,
but let's define it first of all.
Sure.
Now, I mentioned it doesn't necessarily mean it's for the elderly.
It does not mean, it's not isolated to folks that are of a certain age, let's say.
Of a certain age, that's tactful.
Mature clients. No, it could affect anyone that has some type of a learning disability, a physical disability. There's a whole branch of elder law that deals with folks that are dealing with some of those issues. It also deals with folks of a certain age. And also, I'd like to define the difference between elder law and estate planning. They are different, but they're very related. Estate planning is at the time that you pass. You're planning for, today I'm planning for what happens when I pass and where do my assets go and who's going to be responsible for transferring those assets and who gets what and who doesn't get what.
And you're doing your will and your living will and
you got
your
it.
Power of attorney. And
You've heard this before, I have a feeling.
Well, I know
a time or two.
There's like a process and you're
right.
wonderful at reminding us all the things we need to do. Go ahead, I didn't mean to interrupt.
Not at all. So elder law involves all of those things we've talked about with estate planning, but it also talks about how is it that I protect those assets that I have during my lifetime? How is it that I maybe get some benefits that could help me be able to live at home indefinitely or assist with paying for my stay if I need to leave my home or I need to have help inside the home? How do I pay for that? So elder law not only deals with transferring those assets, handling your affairs after you pass away. It also addresses how is it that I protect my assets during my lifetime? How do I secure benefits if I have a child that maybe has some type of a disability, a special needs person, or as I'm aging, I have a dementia and I need help in the home, or just have physical ailments and I'm looking for that help in the home, or I can no longer stay in my own home and I need to move to perhaps an assisted living facility, or I'm looking at perhaps a nursing home stay or a memory care unit stay. How is it that I am able to protect my assets, still get benefits? And also those documents that Sandy was just mentioning a moment ago, how is it that I put things in place? A durable power of attorney, for example. This is a classic. Everybody needs a power of attorney. Healthcare representative designation. So if I can't make decisions about my own health care, who is it that's going to make those decisions for me? If I don't have those things in place, I would need to go to court and have a guardianship established. Nothing wrong with guardianships, but they're expensive, they take time in the court, it takes a little bit longer to get set up than people recognize. So if you can take charge of your own destiny while you're alive and healthy and competent to make those decisions, it's always much preferred that we have those things in place.
Okay, so then there's a definite difference between elder law and
estate planning. For sure.
Or how do they? Well, all right. Let's talk about how they're different, and then how they come together.
Sure. How they come together is really that estate planning part of it, because estate planning is a part of elder law.
Okay.
I like to say that every elder law attorney does estate planning. Not every estate planning attorney does elder law.
Oh.
So there's plenty to do for both types of attorneys, without a doubt. But with elder law, it's probably a little bit more of an in-depth conversation that you're going to be having. They may be able to issue spot things that an estate planning attorney may not be able to issue spot and say, if we do this, in the future there could be a consequence. Oh, you're wanting to gift today? That's fine. However, let's be aware that when you're gifting that you may cause an issue trying to get benefits in the future. So your elder law attorney is probably having a more robust and more thorough knowledge of things that could affect you as you age, or if you have some level of a disability or a loved one that has some level of a disability. So they meet on that estate planning side. What happens when I pass away, how they differ is that elder law is really looking at protecting assets during your lifetime, getting those benefits if you're appropriate for those benefits, and securing care for you. Could be, as I said before, in your home, could be at a facility, nursing home, memory care unit. You may be able to receive food in your home. You may be able to receive, as I say, an assistant in your home that's attending to you, attending to your activities of daily living, things like getting up in the morning and bathing and dressing, perhaps meal preparation, doing laundry, cooking, cleaning. So we can secure benefits to do all of those things for you while protecting your assets as well.
So you've been doing this a number of years.
Long time.
Yeah, how many years, by the way?
30
Oh, my
years
goodness.
I hate to admit it, but it's true.
Really? Oh, okay. Well,
Yeah.
see, he went to law school when he was in,
third
junior
grade.
high, right? So in your experience, what do normally people come to you for when they say, okay, it's time for me to speak to an attorney that specializes in elder law? What's the usual problem, if there is such a thing?
I think that normally I see people, when we're talking about estate planning, I see people typically, they have their first child, right?
Oh, okay.
So they may not have a lot of assets, but they have this precious newborn, and they're concerned what happens to us if we become ill or we pass away. Who's going to raise the child?
Yeah.
So oftentimes I'll have clients come in initially for that, and they're really just focusing on estate planning.
Young families.
Yep.
Okay.
I think the next time, typically that I'm seeing people, if there's some type of an unexpected illness, so I'm a little bit younger, I have an unexpected illness, I didn't get my estate planning in place, I haven't even thought about getting care in the home. So oftentimes I'll have people that they have something like that's happened to them. The next time that I normally see people is when they are either getting ready for retirement or they've just retired. This is one of those boxes that they're ticking off. Oftentimes I've spoken with their financial advisor, and their financial advisor is saying, look, I'm planning for you financially to be able to live successfully for the remainder of your life, and I've been harping on you for the last 20 years to get your estate planning in place. You haven't done it, so now's the time. I'd like you to speak to an estate planning elder law attorney. Strictly for elder law, I think that when folks are going into a nursing home, when folks are going into a memory care unit, and all of a sudden they're writing an $8, $9, $10, $11, $12,000 check per month, and they're saying, wow, I wasn't aware of this huge expense, and they start seeing their assets decline.
And they worry.
And they
Am I
worry.
going to have enough?
Am I going to have enough? Especially if I have married clients, right? Other elder law attorneys, I'm sure, experience this as well. So the well spouse, sometimes we'll call them the community spouse, they're concerned because they're seeing, oh my gosh, I'm spending all of this money. How I need to live as well. And so,
what will I do if I have to go into assisted living?
How am I going to help myself if I've spent all of this money?
Yeah.
Or people have an illness or a condition that comes on in their 60s, 70s, 80s, and we didn't do that planning in advance like maybe we should have, and I need a little bit of help in the home. I can't care for my loved one 24 hours a day. I always said I was going to, but it's very challenging. It's very difficult to take care of someone every hour of every day of the week, every day of the month, and they just get overwhelmed. So those are often times that I see people coming in. Ideally, though, I would love to see folks before it is that they have some type of a condition and I need to emergency in a crisis situation protect their assets. I always like to see people in advance, if at all possible.
Well, you talked about, taking, whether or not you can take care of yourself, and sometimes you just don't know. That's the hard thing, and you don't know how long you're going to live. How can I say this tactfully? I mean, and I'm sure people will ask you as an attorney, Okay, help me plan how much money I need for the rest of my life. How do you decide? What does that mean? What is the rest of your life?
Yep. So how I answer the question when people are talking about, do I have enough assets? Do I have things in place for that? I look at what I do as being part of a team. So as an elder law attorney, I'm looking at working with their financial advisor. I'm looking at working with their CPA. So as a team, we're making a determination, or helping the client. I shouldn't say we make a decision for them, because we don't. I always say, I give you the advice, you drive the bus, you do with my advice whatever you want to. But specifically in regard to, do I have enough money to live for the next X amount of years, we would bring in the financial advisor at that time. And if they don't have a financial advisor, I would refer them, another elder law attorney would refer them to financial advisors that typically we'd worked with in the past, we'd had good experiences with.
Good idea. Good idea. Well, we have a phone call already. I knew we would. And this is from Jane. And here's what Jane has to say, or the question she has for you, Bryan. She said, when a will is in place, how does a conservatorship come into play? And then what prevents the state from coming in and taking any part of the estate?
So I'm going to answer the second part of your question first. What prevents a state, so you mean the state of Indiana, state of Ohio, state of Michigan, et cetera, coming in and taking a part of the estate? So the state doesn't get a part of your estate. So the state doesn't get any of your estate whatsoever. We used to have something called inheritance tax.
Yeah,
that's
I think
on the state
maybe
level.
I hear this type of question often.
Maybe that's your concern, is that what type of tax would I be paying at the time, in my estate when I pass? But actually, for the most part, state inheritance tax has been it doesn't exist any longer.
Right.
So your only concern would be federal estate tax. So federal estate tax, we're looking at very large estates, in excess of $13 million per person. So as a couple, we could have $27 million before we are worried about paying any federal estate tax. Now that is set to change in the year 2026. We don't know what the new numbers are going to be yet, but currently it actually, that federal estate tax affects less than 1% of our population. So I'm not so worried about the state taking a portion of your money when you pass away, unless the state has paid for some of your care through a program like Medicaid, and you happen to have assets in your estate when you pass. In that instance, you have the obligation of telling the state that Medicaid, FSSA, that you have received benefits and there is an estate and there are assets there. You let them know so that they have the ability to file a claim in the estate and take a portion of that.
The state would do that.
So
is that what you're saying?
Yeah. So Medicaid is a federal program.
Yeah.
And Medicaid gives money to each state to dole out as that state believes is appropriate.
Okay.
So if the state of Ohio, for example, has given you money to assist in your care during your lifetime, and you pass, and there is an estate in your name which is opened, they have the right to file a claim and get some of that money back, or all of that money back, depending upon how large the estate is. Now, the next part of your question, Jane, is when a will is in place, how does a conservatorship come into play? So I think what you're asking about is maybe a guardianship. So a guardianship would only be in play during your lifetime, and so your will and your estate planning wouldn't necessarily affect whether or not a guardianship is established. You could, in your will, if you had young children, or someone that, an adult child maybe that you were caring for that had special needs, in your will you could indicate who it is that you wanted to watch your children as a guardian of their person or as a guardian of their money, their estate. That you could say in your will, but a conservatorship would be during your lifetime, not when you pass. So to your question, when a will is in place, how does a conservatorship come into play? It really doesn't. It would just be during your lifetime. As I say, unless you're needing to appoint a guardian for someone, then in that instance, in your will, you would indicate, this is who I want to raise my child, care for my adult child with some type of a special needs, something like that.
What's the difference, Bryan? And I ask this because it seems like conservatorships are kind of in the news now, in the celebrity world, if you will. What's the difference between a conservatorship and a guardian?
Well, the guardian is the person that is taking care of we will say the ward or the subject of the guardianship. So the guardian is the person that's looking out for them, and it could be more than one person, but we have someone looking out for the person. We could also have someone looking out for their money. So sometimes we'll do that. We'll have one person look out for the person themselves and one person manage the money. So we have somebody that's fantastic with kids, and they're the ones that we want to show our children love and affection and instill in them the morals that that align with our morals, etc. But that person couldn't manage money. So we might have somebody else manage the money. But as far as the difference between the two, we normally say a guardianship. Yeah, not a conservatorship.
Okay, all right. So that's just kind of a trendy
could be
word right now.
Well, and now, so some states may use that language.
I see. Okay.
I was talking about tax a few moments ago. One state may call the state inheritance tax, and another state may call it an estate tax. So you might hear a little different from state to state.
Got it. Okay.
Yep.
All right. Okay.
Great questions, Jane. Thank you so much.
Yeah, thanks, Jane, and thank you for watching us here on Life Ahead. For the rest of you, give us a call, 969-2720. And if you're out of the immediate area, that's okay. We make it toll-free for you if you just dial 1-866 right in front of that phone number. Okay, Bryan, let us talk a little bit about discussing some of these issues or planning with a client. What do you expect of them? When they come to see you the first time, what should they bring to you or be prepared to discuss?
Great question. I think that first they need to be aware of generally what it is that they want to get accomplished. I think that they need to bring with them a general idea about their assets and their income. I always say to my clients, it's not that I want to be nosy, but when I know what it is that you have, how the asset is invested, it lets me know what we can and can't do with those assets. It really gives me some great information. I also like to say to folks that are coming in to see me, and I would encourage you folks as you're speaking with your elder law attorneys, estate planning attorneys, don't come into that meeting with a preconceived notion about what you're going to get accomplished or what it is that you're going to end up with, because there should be a free flow of conversation between you and your attorney of choice about what it is that you want to get accomplished. Don't worry about talking legalese. Don't worry about, I saw this on the news, or I read, I saw Bryan on PBS and this is what I need. No, just come in and have a general conversation about the situation that you're in, what you want to get accomplished, where you want to be, and then engage with the attorney to reach a conclusion, a goal that's most appropriate for you. We're really here to help. I enjoy helping my clients. I like putting it together. It's like a giant puzzle. I like educating them. And in fact, I think that that's all we as attorneys do. We educate our client. The client ultimately makes the decision. We have no decision-making ability. We give them the advice. We make recommendations. A majority of the time, you're going to want to follow your attorney's recommendation, but there are unique situations where you can say, I understand what you're telling me. I understand, for example, I understand a trust is going to avoid probate. I understand that you're saying to me it's a good thing, but I don't want to use a trust. I want to use a will.
Yeah.
Okay, so I'm letting you know this is my preference. I think it's, in the long run, it'll serve you better. It'll be less expensive. It'll be faster for your heirs, all those types of things. But if you don't want to do it, we won't do it. We'll do a will. So come into those meetings, though, with an open mind. I think that's the first thing to bring with you. I think number two, you need to have thought about what it is that you're wanting to get accomplished so you can give a little guidance to the attorney to guide them in their conversation with you. And then finally, if you are able to come up with generally those assets that you have, where they're located, how they're titled, that will help your counsel tremendously in giving you some guidance.
Like the amount of money or
not
assets
only amount,
they have.
Sometimes people they're so stressed about giving me the dollar amount to the penny. Well,
It's not that.
give me a day. That penny will change. So I just need to know generally where you are. But more importantly, are we talking about annuities? Are we talking about life insurance policies? Are we talking about IRAs? Are we talking about a brokerage account?
Or physical assets.
Physical assets,
land
right.
or real
all of
estate.
those types of things.
Okay.
Right. That's what we're really needing to get a handle on, because that starts to shape what we can't do. For example, let's say I have a farming client that has, I own 2,000 acres, and I have 5 kids, and I want to treat the kids equally, and I don't have a large savings account, and I want to give the entire farm to 2 of my children. Well, that's tough because I've got 5 kids. Most of my assets are in real estate. I don't have any cash to balance it out. So, but you've come to the attorney with, here's my problem. I need to talk about a solution. Here's my major asset, the real estate. We think it's worth X dollars. Here are my other assets that are more liquid. And so that's the information that you're bringing to your attorney. That's the problem that you're bringing to the attorney, so the attorney can assist you in solving that and getting where you want to be.
We have another question,
Yes,
Bryan.
we do.
And this is from James, and this is what James wants to know, and I know you've suggested the answer already. Are you ever too young to start a will? What is the ideal age?
So you're never too young to do a will, so long as you're, 18 years of age or older, and then there's an exception for, I'm thinking it's merchant marines, or there's some type of an exception based upon military service.
Oh, okay.
But generally 18 years of age or older. So no, you're never too young to do it. In fact, I like when my clients, their children are going off to college, frankly, I like my college age clients to have in place power of attorney, healthcare representative designation, HIPAA waiver form. So if something happens when you're away from home, we assume that our parents can automatically make all these decisions for us. They can't. Once you're 18, you're an adult. So remember I was saying earlier about avoiding a guardianship.
Sure.
So if something happens, your parents are going to have to go to court, going to have to establish a guardianship, go through that whole process, have a doctor's opinion, et cetera, et cetera. So if my college-age students have that power of attorney in place, that healthcare rep, that HIPAA waiver, if we have a medical issue, your parents can come in, can talk to the doctor, talk to the hospital, et cetera. If you need to have your parents do something with your checking account back home, your parents with that power of attorney can go to the bank and can help you out. So ever too young for a will or doing some of these things? I don't think so. At all. There is something called intestate succession. So if you pass away and you don't have a will, then there are statutes, laws, that will determine where your money goes.
Is that the same for every state, Bryan?
Nope, it's different state to state. So every state will have, I can't, again, I'm licensed in 4 states, I can speak to those. My assumption is that every state has intestate succession laws. But so if you don't determine in writing in advance where it is that you want your assets to go should you pass away, we're going to rely on those state statutes that say it goes to my parents, it goes to my siblings. There's a whole chart that it goes through. So it may go where you want it to go, it may not be going where you want it to go. So to answer James' question earlier, I don't think you're ever too young to do it. And I'm always interested when I get clients in their 50s, 60s, 70s. They've had children successfully, grandkids, and they've never done any estate planning. So they were very lucky. They got off the hook, that nothing negative happened, and they survived that long. But no, everybody should have estate planning without a doubt. Yep.
We have a phone call that's online, I think. Ron, are you there with us tonight on the phone?
Yes, I am. Good evening.
Hi,
Love
Ron.
you, Sandy. Love the show.
Thank you. Thank you so much for watching.
Yep.
Do you have a question for Bryan?
I got 2 real quick.
All right. Take your time.
Okay, I had a will made up 2 years ago. How often should I review it? That's my first question.
Okay.
Number 2, I have it all set up. I just have 2 daughters. It's just me. And then my 2 daughters, they're older. I have them as my beneficiaries. Mm-hmm. They each get 50-50 in the will.
Great.
Okay.
Do I need a trust, living will, or anything? All of my accounts, my brokerage accounts, savings accounts, all that is in a TOD, transfer upon death.
Got it. Transfer on death. I know that one.
Okay, so to answer your question, Ron, I think beneficiary designations, transfer on death designations are great in some instances. The only thing that I make people aware of is if you're saying, for example, if my daughter passes away, heaven forbid, but if my daughter passes away and it goes to her children and her children are minors, do we want the kids to get the money at 18? If we had language inside of our will or inside of a trust that said they don't get it until they're 25, or I don't want the in-law to manage the money for my child, I can't do that with a simple beneficiary designation. With a will or a trust, I could do it. Do you need a will versus a trust? that is really dependent upon what you want to get accomplished and what your assets are. I am a fan of trusts because I avoid the probate process. I cut my expenses down significantly by using a trust. I have a trust for myself. I have my family members I'm doing trusts for, so I'm an advocate of them. However, they're not always appropriate depending upon the assets that you have and what you want to get accomplished. It really is client specific to your assets and what you want to do. And we're out of time.
We are, and I hate that. Yes, I hate that. And Ron, we could have talked another half hour on your question, but I'll tell you what, the good news is that Bryan's going to be back again next month. Let's see, in March, I think like the third Wednesday.
Could be.
20th or something
don't
like
press
that.
me.
Okay, we'll keep you posted here on Life Ahead. Meanwhile, we're going to see you right here next Wednesday night at 7:30. Good night.
The preceding program on PBS Fort Wayne was made possible in part by
Nugen Law, specializing in estate planning and elder care law, emphasizing independence and quality of life. Serving Indiana, Ohio, Michigan, and Florida. More information at nugenlaw.com.